All right, Barry, I am really glad that we did not go ahead with every time they say it depends, do a shot of tequila. We would not have much of an audience left here. But that was incredibly valuable, and it was exciting to see over 40 questions get asked. And we know that those were just the beginning. So remember, ask the experts buttons. If you don't know a question around it, they're going to be there, and they can probably direct you to someone who can further have the conversation, or definitely one of our legal experts. So up next, you got a sneak preview, but now you get the full meal deal. Wayne Schoeneberg is going to take us away. Thank you, Wayne.
Thank you. When I was a young man, I wanted to be a stand-up comedian, and somebody pointed out that I was German and that Germans aren't funny. And so I looked around for another profession, and I did the next best thing. I became a trial lawyer. Now, you just don't become a trial lawyer. You have to have clients. And those clients have to be in a state of desperation. You know that your life is on the ropes when you're sitting in a courtroom next to a trial lawyer. So what I'm going to try and do in the next 30 minutes is tell you some of the things that I learned as a trial lawyer and as an entrepreneur that will keep you out of the courtroom. The one lesson, though, that I want to get across to everybody is that don't do this at home. You need a professional, you need professional advice, and it is a lot cheaper to do it beforehand. If you end up in my office, I mean, it's a disaster, okay? Your life is going. So what I'm going to do is I'm going to talk about contracts a little bit, talk about thoughts of what I think should go in a contract and what doesn't necessarily need to go in a contract, things that you could consider when you're doing a contract. I'm going to talk about various types of contracts that you might want to consider that you'll run across. I'm going to talk about legal entities, ways that you can form your business, and we're just going to go over those in general without going into specifics, because you're never going to be able to make that decision until you've talked to your attorney and your accountant. Then, after we talk about that, what I talk about basically is the three dismal Ds: death, divorce, and disagreements. So we'll talk about divorce a little bit because your speaking business is an asset. It's a business. It's valuable. What have you done to protect it? We'll talk a little bit about that. And then we'll save the last cheery subject, death, and talk about how you can protect your assets in that case. And you're all going there sooner or later, hopefully later, but you're all going there. So let's go back and talk about disagreements. No matter how ethical you are, no matter how concerned you are, no matter how honest you are, you're going to have disagreements in your business. It's man's human nature to disagree. I know that right now somebody's out there going, I disagree with that statement. You're going to have disagreements. And so let's talk about contracts. In your materials, you have some suggested contracts. You should not use those. You should not use those. They're great starting points. And you should read those to find out, hey, maybe I should have that in my contract. Hey, that seems like an interesting thing to have in a contract. The rule about contracts is to keep it simple. Now, there's a 2-page contract in there that I think Russ submitted that is a very nice contract. But when you have 2 lawyers in a room, you always have 3 opinions. And in that particular contract, well, let me give you an example. As you know, I used to represent Chuck Berry. We would send Chuck Berry to Europe to do 20 gigs in 30 days, and we'd use a 1-page contract. It said, Chuck Berry will appear at this place, on this date, at this time, and play for 60 minutes, and you will pay him his money before he gets on the plane. That's all we needed. Now, there are those things that I see in contracts all the time, and I'm the program director in our chapter, and we have people who come to speak, and I don't know if there are other program directors in here too, or if you speak to chapters. I get 7-page contracts for people who are, as NSA members, are going to come speak to the chapter. And I don't read them. I sign them and I send them back. AV stuff. There are things called writers. Everybody has heard about the brown M&Ms. Remember that? All right, that was Van Halen that started that. That was a great idea. It wasn't that they didn't like brown M&Ms. They had a writer. Now, their writer was about 32 pages long. If you ever want to see it, it's on the smokinggun.com. You can go see their writer. But they knew that if they walked into the dressing room and there were brown M&Ms, that nobody read the writer. And that they were going to have other problems, that maybe the sound equipment wasn't what they wanted. So we sent Chuck off to Europe with a one-page contract, and we had a one-page writer, and it covered the rental car and the type of hotel and the dressing room and that sort of thing. But ask yourself, on these contracts that you have between either your vendors or let's just talk about meeting planners. If you get there and you've got your fee in the bank, and the tables aren't set up the way you want them, are you going to walk? No, you're going to do the presentation. You might not be happy about it, but you're going to do the presentation. You got the money, the meeting planner. You're selling the meeting planner your appearance for a presentation on a certain day at a certain time for a certain amount. And if you're smart, you have that money in the bank before you leave. So now you got the money in the bank, and they're buying your presentation in a certain place. They're not buying, you're not selling table placement. So keep your contracts simple. Only the stuff that you want to, think about it this way. If the deal goes sour, do you want to be in a courtroom arguing over place, time, and money? Or do you want a lawyer like me saying, well, we gave you all of the AV equipment that you wanted, didn't we? And you have to say yes. And then pretty soon what I do is I wheedle it around so that whatever it was that you didn't like becomes just a little tiny thing, and the jury goes, oh, what are they complaining about? So keep it simple, all right? That's important. Now, types of contracts. You're obviously going to have contracts with your meeting planners. Good idea. If you send a meeting planner a 7-page contract, what are they going to do? They're not going to read it, okay? Don't bother. Send them just what you want to talk about. By the way, I want you to do me a favor. I've been a trial lawyer for a long time. I would like you to say 2 words for me. Just kind of shout them out. Not guilty. Not guilty. All right, thank you. It just warms my heart. So, contracts. You're going to have contracts with meeting planners. You're going to have contracts with employees. You're going to have contracts with virtual assistants. The idea is to keep them simple. Go to your lawyer and tell your lawyer exactly what it is that's really critical to your operation. Put that in your contract. There are all sorts of contracts that you can have. Some of the contracts that I hear talked about all the time are non-compete contracts and non-disclosure contracts. Let's talk about non-compete contracts for a minute. Non-compete contracts, and those are contracts you might have with an employee or a virtual assistant or a subcontractor. Those are frowned upon by the courts. Now, you heard Russ talk about judges have bad lunch, okay? Those are equity matters, and they don't have jury trials in those. Those are just to a judge, and they're frowned upon by the courts because you're keeping somebody from working. So if you have somebody who's answering the phone for you or doing emails, you're probably not going to have a non-compete contract with that person that is going to be effective. But if you're a guy like, say, Mike Robertson, you all know Mike Robertson. He's the guy who takes your slides from puny to powerful. Mike is probably here somewhere, but I know he blends in a lot. And there, Mike, all right. In any event, Mike, in his business, or some of you in your business, if he had somebody that was doing PowerPoint presentations for him, working in his business, he could probably tie that person up effectively in a non-compete agreement. He could keep that person from going and making PowerPoint presentations for other speakers, probably for a year's period of time, probably anywhere in the world for an NSA member. Now, I probably couldn't keep that person from working at Taco Bell or IBM or somewhere that doesn't do slide presentations, because the courts don't want you to prohibit people from working. So the idea is keep it simple. Yeah, now you can put, somebody's out there saying, well, I've got this contract and it says this, and this goes to non-disclosure agreements too. If you don't have some really secret sauce that you're protecting, your non-disclosure agreement doesn't mean a thing. I've seen some of them, actually some of them from members of NSA. They just don't cut it. But you can put anything you want in a contract. You can write up a contract for anything. It's enforcing it. And that's where the problems become. That's when you get into my office. That's when the bell starts ringing. You know, we call these the 3 dismal Ds: death, divorce, and disagreements. Well, that's what lawyers call them when we're talking to lay people. When we're at the country club, sipping our drinks over our 2-hour lunch after coming in from the golf course, we call these the 3 big dollar Ds. They are the grease that keeps the big gears of the legal machinery running smoothly. My goal here today is to keep you from being grease monkeys. Okay? I want you to take these things to heart. This is the money stuff. All right, let's talk. This subject makes me break out in a sweat. We're going to move from that to divorces. I'm an expert in divorce. I have handled divorces for over 20 years. I quit doing them a long time ago, quite frankly, because they weren't remunerative enough. I've also had plenty myself. So I know a lot about divorces. And I can stand up here and tell you how to protect your assets in a divorce and talk about things like prenuptial and postnuptial agreements ad nauseum. First of all, a bunch of you are out there saying, well, divorce, harumph. I love that word, harumph. Harumph. A divorce is never, I'm not even going to listen to this because a divorce is just out of the question for me. I'll never be divorced, and then the rest of you I know are married. So, rather than talk to you about prenuptial agreements, I'm going to use what we trial lawyers call demonstrative evidence, and I have 2 volunteers. Would you all come up here, please? At one point, oh, here we go, thank you. I was going to say at one point I was promised a hand mic, and there it is.
Are we divorced yet? Do I got to go over there?
Stand by, stand by. And you are?
I'm Carolyn.
And?
Carl.
Carolyn and Carl are volunteers, and I thank them for that. Carl, that's for you. Carolyn, that's for you. Now, Carl, what does that say on the front of your envelope?
I'm a songwriter.
Wonderful. And Carolyn?
My speaking business.
Okay. Well, by the power granted to me by the National Speakers Association, and for this demonstration only, I now declare you man and wife.
Oh, cool.
Carl, I want you to open your songwriter envelope there and tell us what's in there.
There's nothing in there.
Okay. Carolyn, would you open your speaker? Just tear it on open.
Okay.
What's in there?
I have $40 from my speaking business, which is about right.
We'll call those.
Okay.
We'll call those
Money.
thousands. We'll call
Yes,
those thousands.
thousands.
All right.
Okay.
So now that you're married, would you give him $20, please?
Sure.
Okay. All right. Because since you're married, that's now marital property. You didn't have any plans or agreements beforehand about how you were going to divide this money that was your speaking business, did you?
No.
Okay. All right. So now you
But he's gonna
have
spend
you
that
have
on
half
me.
of it.
Because he loves me.
So you both have a half interest in that, and just because I love to see people get married, I give you $10. You hold that side, you hold that side, and that's more marital property. So now your marital estate is worth $50,000. Those are thousands, actually. The zeros are just $50,000, which is pretty good, right? Okay, give me the money. Give me all of it.
You're the what?
because you just got divorced. Now, you didn't have any agreement about how you were going to divide this. You didn't have one before you got married, did you? And you didn't have one after you got married? So now the divorce court gets to decide that, right? And I'm the divorce court. I get to be the judge and the lawyer. So I've thought a lot about this. And Carl, because you have put up with Carolyn for all these years, you get $10 of the $50,000. But you came in with nothing, so that's not bad, all right? Okay. And then Carolyn, because you have been out working hard and doing all these speaking engagements and been away all this time while Carl has been sitting at home playing video games, you get $20,000. Oh, I'm the lawyer, I get the other money. Okay? So, postnuptial, get out of here, thank you. So, postnuptial agreements, putting this down. Postnuptial agreements and prenuptial agreements are about the same thing. They are agreements that you make for the disposition of your assets, of your marriage. I mean, a marriage is nothing more than a business relationship that is complicated by romance. The two of you get together and you come to it, and some of you bring big assets. Or your assets grow. And some of you come in with nothing. And when you get together, before you do that, you've got to have an agreement as to how you're going to treat that. Now, I know that seems cold and sterile, so what you do is you say, honey, I love you. And we're getting along famously right now, but there are places along the road where we may stumble and we might have to talk about a divorce. And if that happened, I would want you to be treated fairly. So right now, while we're not mad, let's decide what that is. You think, well, I can't do that. And I say to you, you're speakers, you're professional speakers. Put on your A game and sell that. Because I promise you that if you don't do that and you get divorced, look at it this way. The bad news is that half of all new marriages, first-time marriages, end in divorce. Now, the good news is that about half of all first-time marriages last forever. That's either good news or bad news, depending on who you're married to. But if you're at that point where you're about to get into this marriage, why not take the time to remove the uncertainty and insecurity that is going to undoubtedly invade your marriage at some point? I promise you that at some point there's going to be insecurity and doubt in your marriage if you are married. Hopefully you get past that. And maybe having this agreement in writing about what's going to happen if you do get to that point is going to help you. But if you think your business is an asset, treat it that way. It's important. It's important to your marriage. Look, if you have an honest and open discussion with your spouse about your finances, it's going to leave more time and space for romance. And that's really what we all want, isn't it? Okay. So, when the time comes for you to get the prenuptial agreement or the postnuptial agreement into effect, are you going to be guilty or not guilty? Okay, thank you. I love that. All right, but that is important. If you get in a divorce, so now you've ignored me and you're not going to get your prenuptial agreement or postnuptial agreement, and you're in a divorce. Divorces are really procedures to break up a financial arrangement. Now, let's take child custody out of it because that's a different emotional issue. But it doesn't matter to the courts, to be real honest with you, or to your lawyer, even at $400 an hour, how poorly your spouse has treated you. Take that, that's what your friends and your family are for. Take that drama out of there. The idea of a divorce is to get through it in the best financial shape as possible. I told you these are 3 dismal Ds, but there are things that you really have to pay attention to if you want to protect your business and you want to protect your assets. And divorce is a reality, and I hope that none of you get divorced. I know that the divorce rate among professional speakers is probably very low. I know it is among lawyers. But seriously, I want you to think about it. I know it sounds cold and hard, but it can. And for those of you who are in second marriages, there are a lot of people in second marriages, blended families now. A postnuptial agreement, if you have not done a prenuptial agreement, a postnuptial agreement is simply, let me give you an example. My wife, I have won the wife lottery, by the way. I have the most wonderful wife in the world. Thank you, thank you. I had to buy a lot of tickets. But she has children from a previous marriage. I have a child from a previous marriage. And there are certain inheritance things that we want to take place. And so in a postnuptial agreement, we can take care of those. She will waive certain rights to inherit things that I brought into the marriage, and I will waive certain rights to inherit things that she brought into the marriage, so they can go to her children, my things can go to my child, and then we can leave certain things to all of the children. That's a postnuptial agreement. It is not a declaration of war. So stop and think about it. All right, our last fun subject is death. I say, well, all right, we'll see, so far. And just to sweeten the pot, I want to throw in disability, so now we have 4 Ds. And disability is important, and I do want to bring that up to you, because there are ways that, I mean, think about it. If suddenly you were disabled, what would happen to your business? Have you planned for that? You know, most people don't have estate plans, except what the state has constructed for them. But you need a durable power of attorney. Write this down. This is important. A durable power of attorney. If you have a power of attorney and it does not say in there that it's a durable power of attorney, if something happens to you and you become incapacitated, that power of attorney lapses and is no good and can't be used. So why is that important? Serious injury, serious illness can suddenly thrust you in a position of incapacity, and your business comes to a grinding halt. This business is an asset. You people work hard at building these businesses. I have learned so much from my NSA fans, or fans, both of them, friends, about how hard they work to make their businesses viable. Treat it like a business. So have something in effect that should a serious injury or illness befall you, that business can go on, at least temporarily. And the other thing is a medical directive, or what we call a living will. Tell people what you want to happen. I want to talk finally about your estate plan. One last thing on the living will. I know you all love videos. You all make videos, and I think that's wonderful. What I have done is I have made a video. Not only do I have a living will, and these have to be carefully executed. Again, you can't do this yourself. You can't pull one down off the internet and sign it. It's got to be done exactly correctly. And doing it just on DVD is not enough. It has to be in writing. But there's always that discussion. Bill didn't really want to do this. He was despondent that day. It was a terrible thing. We shouldn't pull the plug. He wants to live in this vegetative state for the next 20 years. Do a DVD and say, look, hey, here's my living will. I did it today on February 23 of 2017. I'm of as sound mind as I ever get. And this is what I want you to do. And stick it in a safe deposit box so that your spouse or your durable power of attorney, person has your durable power of attorney, doesn't have to get involved in a big court battle. I am cheating myself out of so much money here. It doesn't have to get involved in a big court battle about what your wishes were. Because I will tell you, I promise you, that if you have a living will, even if you have the living will and it's properly executed and everybody knows about it, somebody's going to go, I just can't do it. He really didn't want this. So do that. The estate plan. Now the end is near. And as you face the final curtain, your estate plan, your will, is like your last keynote. It's going to be your last opportunity to be heard. Now, you're going to be dead, and as hard as it is for you to believe this, somebody else is going to be in control. So how are they going to know what to do with your stuff? You're going to tell them. You're going to tell them in your will. I know that some of you work hours and days and weeks on a 1-hour presentation to give to somebody that, quite frankly, you know that within a week hardly anybody's going to remember. I mean, that's just, it's not a reflection on you, it's just a reflection on the way it is. And so this last keynote that you're given is going to be, it's going to be there forever. And it's going to be important to people that were important to you, to people that you loved. And so how do you want to show up for your last keynote? You know, say, well, he was unprepared. He really didn't, you know, I don't know what he's going to do with all this stuff. I mean, it's a mess. Did he have an insurance policy? I don't know if he had an insurance policy. It doesn't say anywhere. Well, what did he want done with that bank account? Oh, I don't know. Well, how about the speaking business? We got a garage full of books. What are we going to do with those? Take the time to show your loved ones how much you love them. Go to an church. None of this, I promise you that none of this that I'm telling you about is expensive if you do it on the front end. And that all of it is terribly expensive if you do it on the back end. It's just a fact of life. You can always save more money for your heirs by having an effective estate plan than the attorney's fees. It's just that simple. I mean, attorney's fees to run an estate through, and that runs from state to state, by the way. A lot of the stuff that I'm telling you is going to vary based on your state. And so that I can fall under the big umbrella of disclaimers that we've been saying, and none of this that I'm giving you is legal advice, and you should not rely on it, and all the rest of that. In all seriousness, you've got to go to a lawyer in your state to get this done. Do it because it's the right thing to do. Do it because this is a business. To get some of these things done is going to cost you less money than you paid to come to this symposium. And you will be negligent if you don't do it. Now, I know that there are also other devices. There are trusts that you can have done. There's just not enough time to explain all of the things that you can have done. Go to a lawyer. Establish a good working relationship with a lawyer. I have clients that have been with me for 40 years. And some of them I don't see for 6, 7 years. They don't come in until they have a problem. But they know that they can call me and they can come see me, and we avert problems before they become critical. Do the same. A lawyer isn't going to charge you. Go in and find some lawyer. He'll love the fact that you've come and shown your trust in him or her. And sit down and tell them about your business. Educate them about your business. Get their advice as to what kind of business entity. Oh, we didn't talk about business entities. Sole proprietorship. That's just you. Very dangerous. A lot of liability there. I recommend against it. That's like the lemonade stand at the end of the driveway. And it's okay if you're selling lemonade, but if you got a business where you're traveling all over the country and you're giving big speeches, probably not good. Partnerships, also very dangerous, interestingly enough, because you got to really know who you're in a partnership with. Limited liability companies. Limited liability companies are one short of a corporation. Really good instrument. I highly suggest those for a lot of people. That my coaching and speaking business is a LLC. My law practice is a corporation. Corporations are a little more paper intensive. They take a little more work. You have to have shareholders meetings. You have to have board of directors. But in any of it, no matter what you do, get an operating agreement reduced to writing. Now, I'll be around for the whole symposium. If you have questions, I love talking about the law. I love helping people. And so feel free to drag me aside, and I'll be glad to sit and visit with you at any time. I want to tell you what a pleasure it has been to speak with you. It is always a pleasure when I speak to a group of people and there is not somebody sitting next to me who might go to jail when I'm done talking. Thank you.
Thank you.
Schoenberg.
Thank you, Wayne. That has changed my relationship to the letter D forever. Next up, we bring back our director of the legal pillar, Russ Riddle. Please help me welcome back Russ.
A couple of quick things before we leave this general contract thing. In those short page and a half at the most, 2, if you absolutely have to, engagement agreements. Wayne might sign those the 7 pages when you're coming to his place, but event planners, they don't want to bother with it. You'll lose jobs over long contracts because they just don't want to incur they're not going to read it, and they're not going to pay their lawyer to read it. So keep them short. It's a lot like Wayne said, who, what, when, where, and how much money are you going to be paid? Think of those. But I want to give you a couple of tips to put in there too. You know, we were talking about client logos. Put as a boilerplate clause in your page and a half contract that says, following the event, I am able, you grant me whatever language you want to use, the ability to use your name and or logo on my website simply in the context of a list of clients. And then you don't have to worry about it. You've got the permission up front. And don't go there now, but on page 39 of your legal pillar material, if you're in a situation where you say, well, I didn't get that written thing with my independent contractor, much less have all that language. It's a one-pager. Again, seek advice using it, but it'll give you an idea of how, okay, I screwed up back then, but that independent contractor and I are still good buddies. I'm going to get him to sign this page. And the law supports that you can go back and retroactively do that so long as the verbiage is very clear. But, you know, you hope that relationship's still positive. Because if it's not, he or she may say, no, I'm not signing that. And then you're in trouble. I'm about to bring up someone that you know very well. She's a CSP. She happens to be in my chapter. I love her to death. I'd like to ask Candace Fitzpatrick to come up here. Sure. If you want to use the stool, you can. All right.
This.
The reason I brought Candace up is because we're going to talk a little bit more about licenses, only this time. The licenses that I was mentioning earlier, that's when you're getting permission from other people to use their stuff. What about the reverse? You can make a lot of money, and I know that perks a few up. It's late in the day. But you can make a lot of money if your content is solid in licensing situations. There's all kinds of models. Sometimes it's you go and they certify you to, here you can use our materials. You have to buy the materials from us, but you can go out and do your own thing now that you've been certified. Or sometimes it's captured within a company. You could do it at that company, but nowhere else. And again, it's like Francine has said a lot. It depends on what the contract says. But there are lots of models. There are a lot of very successful people, some of you in this room, that license your content, certify trainers, and so on. Core Clarity, which is Candace's company, has been very successful at this. And so I wanted us to talk about it. A couple of the things. Okay, tell us about those streams of revenue. And then let's also figure out well, I'm afraid to license people because I don't know what they're going to do with it, even if our contract does say such and such. We're going to talk about some of the legal protections that are put in place. Candace, just introduce yourself. I doubt there's a soul in here that doesn't know you, but tell them about your company and how you do things.
I'm sure there are quite a few of you who don't know me, but for those of you that recognize this, I've got it for you at the back of the table if you've taken the assessment. Now, when I started the business, it wasn't a business. I didn't expect to start a business. And what I had was a way of looking at somebody else's material in a new light, which was scary. And I didn't expect to start a business on it. I did it because I was bored with my job. Anybody relate to that, maybe? I didn't like what I was doing at work, so I did this on the side. I read a book, Now Discover Your Strengths, back in 2003, took an assessment, and said, oh my gosh, this is amazing. I want to know more about it. And they didn't have a lot of things together with their materials at that time. The first thing that I did after I realized, oh my gosh, this is a business, is I hired an attorney. I had to. I mean, I had somebody else's material that I was interpreting in a different way than they were interpreting and taking it to a different level. And with my attorney, I thought, you know, I want Gallup to hire me, and I want them to buy my IP, and I'm going to work for Gallup for the rest of my life. That's what I intended. And we got on a phone call. We shared with them all the information. Now, I hired an incredibly just intelligent attorney. Now, for those of you that are familiar with the StrengthsFinder assessment, it helps you it came from the Gallup organization, and it helps you understand what your top 5 talents are out of a field of 34. There are over 33 million potential combinations of these talents, which makes it hard to interpret it. And that's what my business did, was interpret these results for individuals. When we approached Gallup in 2005, again, I expected they're going to buy it. Of course, they're going to love it. And that wasn't the case. But my attorney had them sign a non-disclosure agreement prior to the presentation so that they could not use my materials, which has been very good for us for years. I mean, it was an incredible boon for the business. Again, we didn't know what we were doing in the beginning. All I knew is I needed to have legal help. Gallup came back with we're going to allow you to utilize the materials as you're using it because, number one, you asked. A lot of people were doing things with their material, and they were not asking for permission, so Gallup was shutting them down at the time. So we were given permission to go forward so long as we did certain things. We had to have the just attributions to Gallup anytime we use any of their material that's trademarked or information from their assessments. We have the Gallup name on there, and we show that just attribution. The second thing is we had to do a consent form so that people understood we were not a part of the Gallup organization. There were certain things that we had to have on there. And I thought, this is all in good, and I was out doing programs. And then one of our clients said, oh my gosh, we want to do this in-house. Teach our people to do what you're doing. Oh, crap. I mean, think about it. You're giving what you've been doing to somebody else, and that's when the licensing started to come in. And we realized we can't control what they do when they're out there, so we better really train them well. And a lot of things came from that standpoint. Now, when you look at your materials, what are you licensing? Are you licensing something that you've created that's unusual, that's different, that nobody can get anywhere else? Or are you just licensing certain materials that they can utilize in their company? I mean, it matters, doesn't it?
Yeah, you see how this was complicated from the beginning because she's wanting to license her intellectual property, but it is interpreting some third-party material, so she had to make sure that was buttoned up in the beginning before she really spent her time. And Wayne said NDAs don't hold up a lot of the times. That's true if there's not really anything secretive about what you're sharing with them. But she had all this information that she had spent time to develop. And we don't use a lot of NDAs in our business, but when you have a situation like this, where you're going to say, okay, we're going to kick the tires and see if this is anything that could work out. And if it doesn't, fine. But if it does, then we'll have a whole different agreement setting that out. So you did it right from the get-go. You
Thank
hear what
goodness.
she said about, they said yes because she asked.
It was as simple as that.
Goodwill goes a long way, and it helps so much. And she has built the business, she and her team, into I call it a machine. It is a machine. And you do have some where you certify, and by the way, they're very picky about who they certify.
Yeah.
Not just anybody with a wad of money and the ability to talk gets certified. They screen them because they want to make sure that they're representing the brand well, that they're trustworthy, they'll follow the legal parameters. You're going to have a snafu here or there, but they are very careful. So you have the two scenarios. You have where XYZ company, you'll go in and certify where part of their T's and C's is that they can only do it internally so long as they're part of that company.
Right.
Period.
That's one side of it.
And then there's others where you certify, they've certified
Independence.
many NSA members to use their materials at large. But tell them about you've got something really cool that helps both on the revenue stream and in the legal protections about your portal.
Well, I have a brilliant CTO, Chief Technology Officer, who created a way for all of their materials to be generated from our portal and have every single piece of material be individualized to the person who was going through the program. Now, we're fortunate because our materials are individualized by nature. You know, people they have their first name, their last name, and 5 talents in a particular order. There are over 33 million potential combinations, which means our portal can kick out over 33 million potential combinations of our charts. But that first name and last name makes it individualized completely. So every piece of paper now has, if it's something that's copyrighted, it has that person's name that it was created for. And what we realized up front is the only thing we could control, the only thing that we would know is how many people are entered into the portal. So we license based on those people that are in the portal. You know, you have to look at your materials. If you have a book or a workbook or something that you're licensing and you're selling to someone, you have a different choice to make because you can't individualize each one of those necessarily to the person unless that's what you do, unless that's something that you decide you're going to do and make it individual to each participant in the program. So when you're going in and looking at licensing, there's so many different things to look at. We have different levels of licensing, and they get different, they're allowed to get different materials at each level. The portal will only give them certain things if they've paid for instance, a coaching license or an enhanced coaching license, which has more material, or possibly an individual program where they have a group and they're presenting to a group of people. Or if it's a team, that's the highest level. So those licensing levels make a difference, and what they get and what they're allowed to use at each of those levels is very particular.
Yeah, you want to be careful about how they can use the content that you're licensing them to do. You want to have a whole set of guidelines, a brand Bible page, if you will, about how they can and can't use the trademark. And of course, then there's a whole other thing about you have to have that Gallup, all of this. So it's real specific. One of the things as a lawyer, and Wayne would love this as a trial lawyer, is they basically have built-in accounting that you just spit it out and show, here's our piece of evidence, because you have to log on to their portal to do the assessment, and there creates a record there. And oh, by the way, they get money per assessment in addition to licensing, certifying trainers. And so there's several different streams of income happening, but Wayne, you'd be able to prove this up in nothing because of the accounting record that's created. So figure ways. We've got this great technology. Find ways, if it applies in your business. There's no cookie cutter deal. If you've heard some things today, that's a common theme. It depends. There's no cookie cutter thing about fair use. There's no cookie cutter way to license it. There are some commonly accepted things. But for instance, one of the things you're going to have in your contract, if you're licensing out your stuff, is the ability to audit, to go in. They're saying, oh, I didn't do anything those 2 months. Well, isn't it funny? Look what we found in our audit. And so there's so much here about licensing.
Yeah, and Facebook pages. I mean, people are posting, hey, I went to ABC's program just the other day, and I mean, the client can look that up, can't they? Mm-hmm. And see that, wow, I don't remember them licensing for that particular program or that particular day. You have to be so careful on our side, both ways.
Right. You want to be careful about the duration. How long are they? Train the trainer, they paid this price, you certified them. How long is that good for? Is there a renewal fee?
Is there recertification?
Right,
recertification. At some
recertification.
point, are you going to look at them down the road and say, hey, you have to do these certain things to stay certified?
Early on, I became a certified Ziegler trainer, where I go around and it's cool because they sell the thing, they just tell me where to be, and they do all the logistics. But they also allow me to take their programs to other places. But guess what? I can't just photocopy their manuals and give them out. I have to buy per trainee, per participant, their manuals. And I know many trainers that do that. So it really is figuring out where your business is, what it is you do. Is it e-learning? Then it's kind of like the portal thing in that you give them access for so long. They have passwords and user IDs. What is it in your business that you can license out?
Yeah. And look at it as a stream of income. When I started doing this in the very beginning, 5 to 10% of the income of the company came from the licensing side of it. I just ran the numbers for last year. It was 62% of our income for last year came from licensing that we didn't touch. This is stuff that, came from our portal. Thank you. Yeah. It's huge.
They don't know, Barry and Anna don't know I'm doing this, but we've got a little bit of time. We're a little over, so we're going to stop at the 5-minute mark. But what questions do you have maybe that Candace could answer? It could be a legal question. It could be a stream of income question.
I don't answer legal questions. I'm
No,
going to refer that to the attorney.
I'll jump in front if that happens. Anything. We'll repeat the question so it's on the recording. Yes, sir. Okay.
Not for long.
Well, good afternoon. I'm Patrick from Albuquerque, New Mexico. And my question is, I am finishing a book. The book is copyrighted. I went to an attorney, an IP attorney, and said, in this book is a process. So I derive a process. And he said, that's great. Your work is protected. The process cannot be. And I said, boy, this process you can license. And he said, no, you can't, because you can't protect the process.
That gets back to something that Francine said. Copyright
Yes.
doesn't protect a process, but
Yes.
it might be patentable. I'm not telling you it is.
It's not, because I asked
Okay.
that question next. He said, under the current interpretation of patent rules, the way it's gone the last couple of years, he said you can't patent this either. So I'm curious what is the licensable component that's protectable? Thank you.
Well, I assume that your process, if you will, is based upon the content of your book and the applicability of that process as it uniquely relates to your content. So we could certainly say that there's a level of protection there by copyright, and I'm going to allow you to use this process with this, because the process without any content is kind of worthless to them. I'm not saying to you, but I still think we could. You're not getting incorrect advice, it doesn't sound like, but I think we could craft a way to license it, and we just spell it out as to what you're paying for, how you may use it, and that sort of thing.
Well, isn't there a possibility of creating a training program and a workbook that goes with it, and they could sell the workbooks?
The process
to
itself
facilitators.
might not be protectable, but you could put that in other iterations that are protected under either copyright or something, and you could create workbooks. What else? What comes to mind that maybe?
Oh, well, we're so individualized. I mean, everything
That's
that we
true.
look at is about that one individual. So we're so fortunate. But I will tell you, it was the most difficult path I could have gone on. I wish we had something general sometimes because it would have been a heck of a lot easier and a lot less expensive.
Sure.
There's a lot of expense when it goes into when you're involved in getting a licensing program together.
But get the wheels turning.
Yeah.
It's not just about the proper licenses for their materials, but you have valuable things here. How can you get another stream of income or 4 or 5 coming out of this? Any other questions?
One question all the way in the back. Could you stand, please? This nice and loud, no repeat.
So, when it comes, I'm Jessica, by the way. When it comes to, it's hard to make original thought, you know? And so there's a lot of stuff out there, and when, especially in my work, I'm providing a lot of research, and you read a lot of blog books about a certain topic, and then you take a little bit from here, and you take a little bit from there, and then you make your own system or your own process. How do you protect yourself? I mean, other than like changing the words, and I mean, I assume that's not enough. So, do you want to prevent how do you make
Sure.
copywriters really?
The question had to do with, there's nothing new under the sun, really. It's hard, and so you go, all of us, part of what we get paid for is assembling research. We're doing the research for them, and I don't mean necessarily a scientific-based research or anything, but they could go check out some of these things, but we've gone and checked out those things, and we've put it together, and you certainly don't want to copy any of that stuff, but if it's based on principles, if it's based on core values, anything that really no one can hold the corner on the market of, you can still express, remember, ideas aren't protectable under copyright, but expressions of ideas are, so long as you're not copying others. So just because you went and looked at stuff as part of your research does not mean you can't come up with your own expression, but you do have to be very careful that don't be thinking that just simple little changes and twists is okay. And I don't think any of you would do that, but you can base your original expression of an idea, principle, process, whatever it is, based on research. Just make it your own. Make it your own original. In fact, copyright protects 2 people could be sitting in 2 different locations, and this could never happen, so you'll scoff at it, but theoretically, 2 people could be in 2 parts of the world, word for word, come up with something that's the very same thing, but so long as they didn't have access to that other and copied it, both original expressions of that are protected. Why? Because they're original works of art. Where we started, creative things that you originally did. Doesn't mean it's original as in novel, never been done before. It means you originally created it, didn't copy it from somewhere else.
Yeah, maybe something that'll help Jessica on this also is what I did was I created a framework for understanding and interpreting these results. So if you're taking different areas of research and you're putting it together in a new way and creating a framework that helps people see a problem or an issue or something in a new light, that might be where your particular expertise comes in.
One final question. Who's got the final question right here, please? Would you stand and just nice and loud?
No problem with that. My name is Randy, and my question is for you. You're kickstarting your business. That Gallup story, we all love stories. That Gallup story was really enjoyable. And I'm wondering how much was the asking of Gallup for their permission? What did that do to help kickstart your business? Because you sort of got their approval, if you will.
Repeat the question, if you will.
And then the second part of it is, does Gallup participate in the licensing financially?
Okay, so the questions are, number one, how much was it initially to have them kickstart it or to give me that permission? And number two, are they participating in the licensing on it? The answer to both of those, number one, that catapulted my business unbelievably because I wasn't going to go out there and just do something, with somebody else's material. They did not charge me a penny for it. They do not receive any licensing fees from Core Clarity. What we do is we attribute all of our work to them, and you have to buy a code or a book or something to take the assessment initially. And what we do is we interpret the results of the individual's results. So no, they don't own a piece of it. And in fact, yeah, that's true. Yeah, Gallup owns the assessment, and you pay Gallup for the
So
assessment.
it's a win-win. I mean,
Yeah,
that
it
phrase
is.
is thrown around a lot, but this is
Yeah.
a true win-win. All those initial assessments, Gallup's getting paid for. The interpretations and what you do with that is what Core Clarity gets paid for. It's truly a win-win.
Yeah.
lesson I'm taking away is that you ask permission.
Yeah, you ask permission. That was, I would not have ever thought of doing it ahead of time. I'm one of those people that stop, and it drives my husband crazy, because at 3 a.m, if there's a red light, I stop. And I don't go until it turns. I mean, yeah, so I'm really particular about that, and it has served us so well over the years.
How about a hand for
Thank you,
Candace?
Candace. Thank you, Candace.
And I'm going to do a quick shout out to the voice from the back that you heard was Gary Rifkin. He works in her company with her. You might have heard of him, CSP Cavett Award winner, Gary Rifkin. Thanks, guys.
Thanks, Gary. Russ Riddle from Dallas, Texas. Whoops. Thank you, Russ. Thank you very much. So there are 4 pillars to a sustainable IP speaking business. There's a legal pillar, there's a financial pillar, there's an operations pillar, and there's a marketing tools pillar. And we're coming to the summation of the legal pillar. We can't say enough about our sponsor for this portion, for this pillar. NSA, as we've all known for decades, no organization, no association where people give so much of themselves. And she not only gave of herself, but she invested in this conference. And she's going to bring our legal pillar to a conclusion. One more time, will you please welcome Francine Ward.
Thank you. Thank you. Hi. It's cold in here, isn't it? At least it is to me. Okay, so my last 30 minutes, I'm going to focus on legal landmines. And actually, it wasn't included, but I want to kind of play off of something that Russ and Candace just touched on, and that's this issue of licensing. About 2 years ago, one of my clients came to me. She wanted to enter into a licensing relationship with another entity, and she gave me this contract and said, Francine, it's like really simple, not a big thing, just take a quick look, and these are my friends. Well, whenever I hear that, I always there's a red flag. So I looked at the agreement, and the first thing I noticed, because she was licensing the right to use their trademark, first thing I thought of was, is there in fact a valid trademark? Okay, so me, being the lawyer that I am, I went and did my due diligence, and what do you think I found? That person had lost the trademark. And not only did they lose the trademark because a couple of years earlier they didn't file their declaration of continued use, someone else came along and got the trademark. So my client was about to enter into a relationship with someone based on a trademark for the trademark licensing relationship, and there was no license. The license was invalid because there was no real trademark. The person didn't own it. I say that to you because, again, I'm just reiterating something I said earlier. The post-registration, formalities are key. If you have a trademark, you absolutely must make sure you maintain it. And that means file the declaration between years 5 and 6 and renew between years 9 and 10. Every 10 years, you have to renew it. You can have your trademark forever, but you must do certain things. So let's talk about a couple of other landmines. Some we've already touched on. Here's the whole list, but I'm going to go through a few of them individually. First is, don't think delete equals delete. Hello, are we still at the stage where we think that? Just because you delete something on the internet, believe me, it can be found. It is there somewhere. So be careful. You've got that mouse in your hand. The president can say whatever he wants. Absolutely. He can say anything he wants. And if he gets sued, he's got enough money to defend himself. Do you? Be careful what you say on the internet, because even if you delete it, someone can go back and find it. We've already touched on this. Use of someone's copyright-protected content without permission, definitely a landmine. This one we've also touched on, not protecting your work, but But here is one I really want to draw your attention to, and that's terms of use. Now, Wayne touched on this issue, but I'm going to look at it from a different perspective. How many of you are on Facebook? Twitter? LinkedIn? Anything else? Any other social media venue? How many of you read the terms of use before you got on there? I see about 3 hands, which means that the rest of you who are on Facebook or Twitter have no idea what you've entered into. So take a look. Take a look. First, before we do that, what you should know about terms of use is, number one, they are not designed to protect your rights. Let me just tell you that. It's not about you. They're not there to help you. You give up a lot when you click I accept on Facebook, on Twitter, on Pinterest, on Google+, the list goes on LinkedIn. Terms of use should be read and understood. Now I do get that nobody wants to read them. I understand that. But if you don't, well, you're going to be liable for what you've agreed to, because they are, in fact, contracts. When you click accept, you have agreed to be bound, and more over the last few years, judges are actually upholding those agreements. So here are a couple of things, and I'm going to just show you what I've done is cut and pasted some content from some terms of use, so you could see that I'm not just making this up. So I cut and pasted this from Twitter, but it's also on Facebook, it's on all of them. This is number one, letting you know that what you're entering into is a valid contract. In fact, it clearly says, your access to and use of Twitter services is conditioned on your acceptance of and compliance with these terms. By accessing or using the service, you agree to be bound. And it also says you may use the service only if you can form a binding contract. So that's one thing. You are entering into an agreement when you click I accept with Twitter. So here's something else. I took another little piece out of Twitter, and it's the same thing in Facebook. And the piece that most of you probably love to read is where it says, you retain your rights to any content you submit, post, or display. What's yours is yours. Isn't that what we like to hear? I mean, that's what we believe anyway, but how many of you read the rest of the print? Where it says, by submitting, posting, or displaying, and I've cut this right from Twitter, it's on Facebook, it's on all of them. By submitting, posting, or displaying the content, you grant us a worldwide, that means everywhere, non-exclusive, that means they have the right to use it, other people, you have the right, but they have the right to use it, royalty-free, you can't charge them for it, with the right to sublicense. It means they have the right to sublicense your work to someone else, to use, copy, reproduce, all the rights you as a copyright owner, you've given to them, adapt, modify, and display your work in all media or distribution methods now known or later developed. Hello? That means you give them the right to do anything they want. That's essentially what it is. It also says, let's go to the next one, because they're all pretty similar. Facebook, you own all of the content and information. Again, we like that piece. But it continues, you give us the right to transfer, sublicense, have a worldwide license to use any IP content that you post on or in connection with Facebook. This IP license ends when you delete your content on your account, unless it has been shared with someone else. Now, you know what that means? That means that even if you delete something, let's say you discover that you don't want Facebook to be able to use it. Okay, so you delete it, and you just assume, well, it's gone. I put it in the trash. Again, delete doesn't mean delete. Because let's say you've got 5,000 followers. You click share, and let's say 1,000 of your followers are right there with you and they accessed it immediately, right before you had a chance to delete it. They're now sharing it with all their people. Your content that you believe is yours to do whatever you want, in fact, really is not. Because 1,000 other people have already shared it, and Facebook has protected itself by saying, this IP license ends when you delete your content unless your content has been shared by others. This is on every single social media site. Here's another one, LinkedIn. And LinkedIn just changed its terms of use were even more onerous. People kept talking about, oh, LinkedIn is better. LinkedIn used to use that assignment language. It has since removed it. It says, again, a worldwide, transferable, and sub-licensable right to use, copy, modify. I mean, again, they can take a photograph you put up and do whatever they want to do with it. That's what it's saying. So people say to me, well, Francine, what am I supposed to do? You know, I have to accept if I use them. And yes, that's true. So what I would recommend is you be careful what you upload. Do not put anything on Facebook. Do not put anything on Twitter that is so valuable to you. And if you do, you want to make sure you register it with the Copyright Office before you do it. So in the event, I'm not taking questions right now, I'm sorry, because they've only given me a few minutes, but I'll talk afterward. In the event you have a problem and you want to sue someone. But I would really strongly encourage people not to put up really valuable content in the social media venues. Next, landmine. So almost everyone I know on social media is advertising. That's the whole purpose. It's a great marketing tool. It's a marketing venue. How many of you have actually ever looked at the Federal Trade Commission website, ftc.gov? One hand? Two. Okay, so here's what I'm going to recommend. You guys need to go there. Go to ftc.gov. I mean, you need to do it as soon as possible. If you are advertising or marketing in any way online, you need to know what the FTC is telling you you can do and what you can't do. There are rules. There's a .com document, which is great. And actually, there is, under the frequently asked questions section, it's a wonderful user-friendly segment that you can read. There's something that speaks to endorsements and testimonials. Read it. You know, everybody thinks they understand that, but you don't. You don't. And the FTC has some really wonderful examples that are very, very user-friendly. I say go take a look at that website. It's really important. And here are some of the takeaways. You want to read the guidelines. Again, I really encourage you to do that. Understand that you could have somebody endorsing your products and it not even be through words. It could be through actions. Compensation. So this is a really tricky area, and I'm not going to go into the whole thing, but I do believe that you should read the endorsement guides on the Federal Trade Commission website. And this speaks to any time you have someone do a testimonial or an endorsement for your product and or service. And essentially what this is about is anytime you have someone who speaks highly of your material in an effort to get someone else to come on board, either to purchase or whatever, you need to take a look at what they're saying, because disclosure is key, but there are lots of other things that you need to take a look at with regard to the takeaways. I'll just leave it at that, because that can be a little tricky. And here's another one that I think is very important for you to take a look at. How many of you have ever done a contest or a sweepstake online? Okay, so most of my clients do sweepstakes and contests online and social media because it's easy to do. However, both state and federal law govern contests and sweepstakes online. The FTC governs it, And whatever state you live in and whatever state you are attracting or marketing to, that state's law actually applies as well. This is not as simple as putting up a contest online and thinking that that's all there is. Number one of the things when I'm structuring a deal like this for a client, we want to make sure that we avoid being a lottery. There's a contest, there's a sweepstakes, and there's a lottery. Contests are games of skill. Sweepstakes are games of chance. And a lottery is where you have to have consideration, where you pay something for the chance, the opportunity to win a prize. Only states are allowed to do that. You are not allowed to do it, and if it's ever discovered that you do that, you will be in trouble not only with the Attorney General, but with the Federal Trade Commission. So you want to make sure you take a look at what surrounds the use of, your use of having either a contest or a sweepstakes. So I touched on this. Actually, we all touched on this one, but I just want to touch on this landmine again, the signing of documents without reading and understanding them. I couldn't do it for this program, but I remember one of the last NSA programs I actually spoke at and did a legal topic. What I did is beforehand, I gave everyone a release that I had prepared. Every single person, I gave them this release, and they had to, maybe some of you are in the room who did it. And I think there were like about 400 people in the room, and I'd say at least 350 signed the release. What the release essentially said was, and I use the term progeny, that you, and I'm trying to remember exactly, but that you give up something about you. I wish I could remember exactly, but it was essentially you give me everything from your last born, their college fund, and you give me like 75% of anything you earn from this point forward. And I'm telling you, the language was so horrendous. 350 people signed that release. Now, of course, I stood up here and I tore it all up. But the message was, had I asked people initially, do you sign agreements without reading, nobody would have said they did. But this was living proof. It was an experiential exercise. And 350 people out of 400 signed that agreement. Now, had that been real, they would have been in trouble. How many of you actually sign agreements without reading? Probably most of you. A couple raised your hand, but probably most. Why? Well, here's why. Because that's what the average contract looks like. Am I right? It's like you can't even read it. I get it. Or it looks like that. Only language a 12-year-old can read. You can't even understand it. I can't read without my glasses today. But that's what they look like. Or they're too long. Or you trust the person. How many of you have signed an agreement because you trust the person that gave you the contract? Absolutely. Or you're too busy. You're just too busy, so you just sign it. Or you feel pressured. I bet you some of those 350 people that signed that release felt pressured to do it, even though I didn't tell them they had to, but they felt pressured to do it. They feel they have no choice. Anybody ever signed something because you didn't think you had a choice? Yeah. Or you thought you understood when in fact you didn't. Well, I can just say this, regardless of the reason for signing something without understanding it, if you sign it, you're going to be held liable for it. And that's just the reality. So it's a smart business judgment decision for you as speaker, entrepreneur, business owners to make sure you read what you sign. I get that there are people who don't do it, but that shouldn't be you. That just shouldn't be you. Because again, I will repeat that in most contracts today, especially contracts that you're going to enter into, there are intellectual property law implications. I'm going to pass this because they've already included this. And in the materials, I actually included an audit of the list of speaker contracts that you might need for your toolkit. The other landmine is using templates without vetting them. Why does it matter? Number one, contract law is state law. Like it or not all contracts are created equal. You'll find a contract online and you may think it works for you, but if you live in California, let's say, what if the contract was created in Florida? Or what if it was created in Maine? How would you know? The law is different in Maine and Florida than it is here. It's different in Illinois than it is in Texas. So you don't know what you're getting into. That's one reason you don't want to do that. The other is, and I've seen this over and over and over again. People will give me agreements that they think are valid, but I can always tell when no lawyer has touched that piece of paper. Not one iota of that agreement was touched by a lawyer. I can tell because the contracts contradict each other. People may put together something, cutting and pasting because they think it sounds good, and they don't realize that they have contradicted themselves by putting two clauses that are totally different. Totally different. The illusion of protection. Again, that often comes when you put together something that's not really, where the pieces don't really go. And also because you could inadvertently give away your rights. Again, I can't stress that piece enough. There are always IP complications or implications to pretty much every single agreement you'll sign. I've got about 10 minutes, and what I want to do here is I want to just briefly touch on this issue of publishing law and publishing contracts, because I've had several people come to me asking me about this. Let me just say this. I think that, one of the questions that often comes up is, should you have an agent and a lawyer? And no, the answer is not necessarily. If you've got a really good agent who understands the issue, especially intellectual property law issues, then you don't really need to have both. So I've had people come to me, if they have an agent, there's really no need to have both of us. So I'll just say that, but that depends. The other thing is the contract itself. How many of you published with a traditional publisher? So that means you've all signed contracts. People often think that the most important provision in a traditional law, in a traditional publishing agreement is what? Throw it out. Royalties, advance. That's what most people say. Well, as a lawyer that represents authors, I'm going to tell you that is not true. Why? Because number one, unless you come to the table with a lot of leverage, you're going to have the same royalty rate that the average person has. You're not going to be able to get more than the publisher wants you to have because you don't really bring anything to the table that's that valuable. You're not a celebrity. With regard to the advance, it's the same thing. Unless you come to the table with a lot of leverage, your advance is going to be limited. Now, when I got my first book published with Random House paid me almost $200,000 to publish my first book. Why? Because number one, I had a huge platform. So that's what I would encourage you to do. That's when I was doing speaking and doing motivational talks all the time. I had a big platform, and I had a compelling enough personal story that Random House wanted, they wanted more. So they were willing to pay me all that money. If you've got something that you bring to the table that you want, then you can negotiate that kind of deal. But to me, the more important provisions are some of these. Well, first we're going to come back to here. Some of the more important provisions are the description of your work. People ignore that section, but that's really important because let's say you enter into an agreement and the description is very vague. Well, if the description is vague and it comes time for you to also negotiate the clause having to do with options, that means you're giving your publisher the right to control what happens to pretty much any work you want to do down the road. If you're focused on cookbooks, then that's what that description should say. And in fact, it should only be the one book unless you're negotiating a multi-book deal. One book, and you should be specific about that book. The grant of rights, again, I can't stress the importance of that. That's all your IP. You don't want to give all that up unless you are not in a position to take care of it. Or unless you believe the publisher is in a better position to take care of it, then you can give it up, but you don't just sign away those rights. That to me is more important than the royalty and the advance, because that will outlive the royalty and the advance. The other one that's really important as I look through the list, delivery of manuscript. Very often, speakers get a little lax about that. It may say June 2017, but the speaker, and I've had this happen, the speaker will just figure, oh, but I was told it's not that big of a deal. Well, it is a big deal. It is a big deal. Every piece in that contract is a big deal, and if you say you're going to deliver the manuscript by June 18th, 2018, then that's when you've got to have it in. Not December or September, unless you negotiate something different. Another really important, the copyright. You may think that automatically you're going to be able to get the copyright in your book contract. Well, if it's a traditional book publisher, they're going to be much more ethical. But I will tell you, without mentioning any names, I've negotiated a few book contracts with people in an essay with vanity presses. We call them subsidy presses or vanity presses. And you know, the rise of those publishing houses is because a lot of people couldn't get published through traditional means, so these little cottage, groups started to come up. I had a contract a few years ago where they tried to take the copyright from the client. And had the client not come to me, they would have signed that agreement and given their copyright away. Be careful what you sign. Be careful what you sign. Something else on here, advertising is another potential problem area. And it might not be a problem for most of you, but for example, in my case, with my first book, it was really important that I not have anything in my marketing materials or in my book that dealt with alcohol or tobacco. I don't drink, and I don't use drugs, and I don't smoke cigarettes. So for me, that was really important. I wouldn't allow any advertising in my book or even around the display of my book that dealt with that. That's a contract issue. There might be some things that you don't want. That's a contract issue. So these are some of the really important points that need to be negotiated when you're negotiating your big contract. Reserved rights. Someone mentioned it earlier about the reservation of rights or the reversion of rights. People overlook that. I would strongly encourage you to not do so. This, to me, is one of the most important provisions in the traditional book contract. Why? Because when the publisher stops promoting your book, when the publisher stops doing anything to support your book, if you don't get the rights back and they retain them, they'll let it sit on the back burner and nothing, absolutely nothing will happen, and you won't be able to go after it and do what you need to do to market for yourself, unless, of course, you agree to certain things in writing. So you want to make sure that there is a reversionary rights clause where, under certain circumstances, you get to take the rights back if they're not doing what they need to do after a certain period of time. You want to be able to do that. Plus, if you do that, you can then turn that book into other materials. Workbooks, you get all kinds of things. You then have the right to do a lot of those things that you might not have had a right to do before. I want to go back to one more thing, this one. In my experience negotiating book contracts, these 4 clauses are never, or almost never, ever, ever negotiated in the author's favor. Governing law almost always is going to be where the publisher is, which is going to generally be New York or San Francisco. Warranties and indemnities, believe me, they are not going to give that up. And why should they? Which is why I make sure my clients understand everything in the warranty section that they're agreeing to. I make sure they understand every single thing they've represented. Basically, it's that there's no violation of someone else's rights, that they're not committing libel, things like that. But I make sure they do, because if it's discovered that they've lied, that they've misrepresented themselves, that they've encroached on someone else's rights, and the publisher gets sued, who do you think the publisher's going to come after? The author. This happened with, remember the book a number of years ago, A Million Little Pieces? That Oprah touted, it was a big book, and this guy had this huge story, and he made millions. Well, it was discovered that he lied. He misrepresented himself, and believe me, there were so many court cases against this guy, it's unbelievable. The publisher took him to task as well. You don't want to find yourself on the other end of that lawsuit. And assignment is another clause that I have found the publishers will just not want to get rid of. And that gives them the right, in the event they decide to go under or merge with another company, they can assign your rights, the rights to your book, to that other company. So those are some of the things that I think are really important. I have a couple of minutes. Anybody have a quick question? Yes?
Okay. So, one, the reason why I don't read Facebook, you can't do a damn thing about it anyways, right? But two, the problem that I have is I was doing a session and somebody took a picture of my stuff, shared it with their brother, and their brother put it on Facebook, not me. How can I protect myself as somebody, like if I took a picture of your stuff, put it up there, and it gets like third party, I can't delete it, they can't delete it. That's the challenge that I have. How do we protect ourselves from that?
That question can't be answered right now. I mean, that's just way too complicated. Because the content, I mean, your work is on Facebook, so you don't own the venue.
No, it's not on Facebook. Somebody else put my work on Facebook.
And where did they get the content from?
They took a picture while I was speaking, just like you.
Oh, well, that gets into a privacy issue too. Talk to me afterward. I'd be happy to talk to you about that. Okay. One more? I've got like a minute. Yeah.
Hi, I have a question that you mentioned about lottery. I showed up at a conference one time that I was brought in as part of six presenters, so there's very few of us. And I was not informed that they were selling lottery tickets to a private breakfast with each individual presenter. So you had to pay per presenter to bid. So if you wanted to bid on 6 presenters, you had to pay 6 $20 bills each time. And I wasn't paid a portion of that. I was not informed of that. Would I be liable if the state government went after them for holding the lottery, that I was the prize?
That could be a whole nother issue, though. You were the prize.
That breakfast time with me was the prize. And I was horrified for any number of reasons. Mostly it was at 7 a.m.
So let me just say, I can talk to you about that, but I don't even know if that would be considered a lottery. So, you know, sometimes people use terms and it's not really applicable in terms of what the law considers that. So I don't even know if that would be considered a lottery, but I'd be happy to chat with you. Anyway, it's my time. Thank you, guys. I'll be around for the weekend.
Very generous Francine Ward. Thank you, Francine.
Thank you, Francine.
Thank you.
Thank you
Thank you.
so
Oh,
much.
This way?
Direct-
Thank you.
All right, let's give one more round of applause to all of our legal presenters today. Thank you so much. Wow. Well, Winter Conference is off to a great start. I want to do a quick pulse here. How many of you, with a show of hands, feel like you've already gotten something that paid for the price of your ticket?
Wonderful,
Oh, that's
wonderful. That's great.
excellent.
That's great news.
That's excellent. Don't keep it to yourself. Go on social media, but don't share anything proprietary, right? But go on social media and use our hashtag NSA2017 and let others know how valuable this has been. And keep doing it all the way through.
And I've gained a lot of things of value I can't wait to implement. But remember, one of the very important things is what we learn from each other. Now, you've probably figured it out 4 hours later that I am not from Boston. I went to school there, but I didn't bring any of that back to the South. And in the South, it's about time we smile and laugh, have a drink together, and have some food. And not only is San Francisco known for big ideas, big brains, it's known for great musicians. Downstairs, some of the most elite musicians of the San Francisco Conservatory of Music are waiting for us. We're going to be going into a reception. Now listen carefully. When we go out these doors, don't go down the escalator. Take a right and go immediately down the stairs and take a right, and you're going to see tables set out over the bay there inside. There's a reception going to be waiting, and we've got a very special surprise.
Yes, we do. We have an internationally acclaimed vocalist who's going to make a surprise appearance. So you do not want to miss this. Now, we've got a couple other things coming up as well. Tomorrow night, we're going to be going into the city. And we've got something for you to do before we go tomorrow. So as we go into the city, you get to choose your adventure. You can either go to a restaurant that we've selected, and our NSA San Francisco chapter has selected a number of restaurants, and a number of them are going to be hosting. Well, by that I mean they're going to, say hi. They're not paying for your meal, right? Okay. Be very clear about that. Legally, am I covered? Yeah,
right.
Okay. But they're going to be hosting. So as you go out the door, if you have not yet signed up for a restaurant, go ahead and sign up, and then you'll go there. Or if you just want to sign up for a neighborhood and you want to have a create your own adventure, then you can do that as well, right outside. We want to say thank you to San Francisco and Jim Ware for heading that up. Let's give him a quick round of applause.
Yes.
Now, the other thing is, we know that you're going to want to mastermind. So as you go out the door to the reception tonight, there's going to be places to mastermind downstairs, and we are going to be seeing you down there with the music and our featured guests.
Now, also, tomorrow night, we have buses that will take us into the city. Buses will be provided to get all of us into the city. They will not be provided to bring us home. You get home by Uber, by Lyft, by however way you wish. Dr. Rick Goodman has given me some bail bonds coupons. If you need those, we've got those for you. So tomorrow night, once you get into the city, there's lots of easy traffic to get home. You can get home by Lyft, by Uber, by cab, but we will be making sure that all the buses take us there together.
Now, we want to make sure you know that tomorrow morning we start at 8 a.m.
Yes.
And it is going to be life-changing information. The financial pillar we're kicking off with, this could change the course of your life, how you use this information. So please have fun tonight, but be here at 8 a.m.
And
sharp.
it's important because we've just learned this afternoon there's some additional points of value, really significant points of value that are going to be given away by both of our presenters in the morning.
Yeah.
Now, the hors d'oeuvres are ready. The wine is uncorked. I think I can hear the music, Anna. Are you ready?
I think I can.
We'll see you
tomorrow.
downstairs in just a moment.